Washington Journal continues.
A roundtable discussion now on today's Supreme Court oral arguments on Donald Trump's eligibility to appear on 2024 presidential ballots. We're joined by two law professors this morning. Josh Blackman is with us in studio. He teaches at South Texas College of Law, Houston. Ilya Somin joins us via Zoom. He's at George Mason University's Antonin Scalia Law School. Good morning to you both.
Good morning.
Mr. Blackman, starting with you, where do you stand on this case?
So I filed a brief on behalf of Professor Seth Barrett-Tillman. I've also written a lot of articles on this. I think that the court should not disqualify Mr. Trump from the ballot.
Why?
A couple big reasons. The first is very technical. Section 3 of the 14th Amendment only applies to a person who took a certain type of oath in a certain position. The language of the Constitution is that you must take an oath to the Constitution as an officer of the United States. The key word, officer of the United States. And for nearly a decade, I've written this phrase, officer of the United States, refers to appointed positions, as people appointed by the president or an agency, not people who are elected. And that this is not referred to the president. Therefore, Section 3 has no bearing on Mr. Trump at all. And this is a position I've taken long before Trump ever came on the scene.
Is this a position that you expect the Trump's counsel to take today during arguments?
Trump's counsel has adopted their position as their lead arguments, number one in their brief. And I think that'll be the primary way they're going to try to win this case.
Ilya Somin, your view on this case in general, where do you stand?
I believe the Supreme Court should affirm the decision of the Colorado Supreme Court, which they are reviewing, which says that Trump should indeed be disqualified because he engaged in insurrection by instigating and then trying to exploit the attack on the Capitol on January 6, 2021. I also believe that he is, in fact, an officer of the United States, or was when he was the president, under Section 3 of the 14th Amendment, and also that the other hyper-technical arguments that Trump's counsel and others have advanced are also flawed and should be rejected.
Explain what you mean by a hyper-technical argument.
So there's a whole bunch of ways that Trump's counsel is trying to win this case, all of which are, for the most part, highly counterintuitive and hyper-technical. They're the kind of things that make people dislike lawyers, which doesn't by itself mean they're necessarily wrong, but it should make us suspicious of those kind of arguments. They have the argument that Josh already mentioned, which is that the person who holds the highest office in the federal government is somehow not an officer of the United States, the kind of argument that only a hyper-technical lawyer can believe. They also have the argument that Section 3 cannot be enforced unless Congress enacts additional legislation to try to enforce it, even though nothing in the 13th of the 14th Amendment indicates that that is the case. And they have a number of other technical arguments, such as the argument that I address in my amicus brief, which is the claim that before Trump or anybody could be disqualified for engaging in insurrection, they first have to be convicted under a criminal charge, despite the fact that all of the former Confederates who were disqualified in the immediate aftermath of an amendment, none of them had in fact been convicted of any crimes related to their involvement in the Civil War.
Josh Blackman, who has the tougher job today? Is it Donald Trump's counsel, or is it the counsel arguing on behalf of the voters of Colorado?
What's unique about this case is in order for the voters to win, they have to arrive at everything. So all the issues that Ilya and I just mentioned, if the court agrees with Trump on any one issue, he's on the ballot. If, for example, the court says the president's not an officer, that Trump did not engage in insurrection, that you need a federal statute, that there's a First Amendment defense, if the court accepts any one of those defenses, then Trump wins. So
why is it set up that way?
In order to disqualify someone from the ballot, you have to basically run the table. You have to arrive at everything. And if Trump's tried at any one thing, the court has to say, you know what, the Colorado court made a mistake, we have to reverse, and then Trump goes on the ballot, and that'll probably be the ruling nationwide in all 50 states.
Mr. Somin, who's got the tougher job today?
I think they're tough in different ways. On the one hand, it's true. Trump has several different possible ways to win, and his opponents have to defeat all of them. On the other hand, each of those ways that he has are badly flawed arguments in various ways, some of them extremely so, and all of them, with minor exceptions, would set a very dangerous precedent if they were adopted by the court. So you have here one side that does have an advantage in that they have multiple ways to win, and they have an advantage. You can argue the court, for political reasons, might hesitate to allow Trump to be removed from the ballot. On the other hand, our side has the advantage that all the other side's arguments are highly counterintuitive and badly flawed.
Let me invite the viewers to join the program, keeping our phone lines as we have all morning long on this issue of ballot access, whether you think the former president should or should not be disqualified. If you think he should be disqualified, 202-748-8000 is the number to call. If you say he shouldn't be disqualified, 202-748-8001. Both of you gentlemen mentioned that you filed briefs in this case. Why and who's allowed to file a brief? How many briefs are there in this case, Mr. Blackman?
Well, the phrase is amicus brief. Amicus, like amigo, meaning friend of the court. And just about anyone in the world can file a brief in front of the Supreme Court. You don't have to get permission anymore to even do it. I filed a brief with my colleague Seth Barrett-Tillman. Seth has been writing on this issue since 2006, long before anyone even knew about this issue. And we want to bring to the court's attention how this argument should be presented. In fact, many of the arguments that Trump has made came straight from our articles and scholarship. This is something that we think the court maybe might want to hear. We'll see what happens today.
Mr. Soman, why did you file a brief?
For two reasons. One is, as an academic, I have a long-standing interest in the structure of democracy and constitutional limitations on democracy, including, in this case, those that try to protect democracy, sometimes against the voters themselves and against voter ignorance and other problems. Second, I thought this argument that I'm addressing in the brief, the argument that there must be a criminal conviction first, it is one that has come up a lot in the public debate, and it's come up in the briefs, but it's also pretty weak. So I thought that I could make a contribution by filing the one amicus brief on our side that is specifically focused on this question.
Two law professors with us again this morning. Ilya Soman joining us via Zoom, Josh Blackman joining us in studio and taking your phone calls. And Linda is up first out of Columbus, Ohio. Good morning.
Good morning. Good morning. I just feel that we need to go on and follow the Constitution to straighten out a lot of things that are happening in America that are negative. These judges need to get together and just do the law as it has been written and follow the law. And Trump, he needs to go home now. His time is up.
Mr. Blackman, we need to follow the law as it's been written. The caller says, why was Section 3 of the 14th Amendment written back in 1868?
Well, I agree. We should absolutely follow the law. I think it's a good sentiment. Section 3 arose from the Civil War, and after the Civil War, there were questions of how do we handle former Confederates, and there were different proposals. One proposal would have said we're going to disenfranchise Confederates, that they can't vote. Another would have said that former Confederates can't hold any government position. There were a lot of proposals. Ultimately, we have something of a compromise that certain Confederate officials cannot hold certain governmental positions. It doesn't apply to everyone in all contexts. And the challenge is figuring out what the law means. So I agree, the argument is somewhat technical, but when you're knocking someone off the ballot, you have to follow the strictures of the law. And sometimes it may not be the most intuitive to people listening at home, but I think there's a lot going for the position that we've advanced.
Did those who wrote the 14th Amendment and Section 3 specifically, would they have been okay with a former Confederate running for president?
So there are two issues, right? One, could a former Confederate run for president? That's actually not the argument we're making. This is the Jefferson-Davis horrible. And I actually think there's some argument that people would not have wanted Jeff Davis to be president, so we're not making that argument. We're making a different argument that if a person took only one oath, like Donald Trump, as president of the United States, would he have been an officer of the United States? And to be frank, every former president had held some other government position, whether it's a general or a governor or a senator or a member of Congress. So there's no reason for them to have even thought about a person who took one oath and only one oath as president. It wasn't on their minds at all.
Mr. Soman?
Yeah, so I think the Supreme Court has said several times, including in a well-known opinion by Justice Scalia, that when we interpret the words in the Constitution, we should interpret them in accordance with their ordinary meaning as understood by ordinary people at the time. When an ordinary person sees a phrase like officer of the United States, they're going to intuitively and correctly think that surely includes the person who holds the highest and most powerful office in the land. In addition, it just doesn't make any sense to say that if you were a low-level federal bureaucrat or a low-level military officer and you engage in insurrection, then you're disqualified under Section 3. But if you're a president and you engage in insurrection, hallelujah, you get a free pass. An insurrectionist president gets an exemption. That is highly counterintuitive. It doesn't make any sense. It's not the kind of thing that an ordinary person would think upon reading the amendment, either in 1868 at the time that it was ratified or today. It is only certainly the kind of hyper-technical argument that is not generally accessible under ordinary meaning, and it also makes little sense in terms of what this amendment is supposed to do. Yes, at that time, the former presidents generally had also held other government offices, but that couldn't necessarily be counted on, and there certainly were prominent people who could run for office or had run for office, even though they hadn't previously held another sufficiently important office to be disqualified.
Who gets to decide what an ordinary person is?
So that's a good question, and the constitutional theorists have different views on this, but I think the usual assumption is that an ordinary person is just simply an ordinary member of the general public at the time, who, if you had put before him or her the text of Section 3, would they think that it includes the highest office in the land or not? And I think the answer is that they would think that, because surely the person who holds the single most powerful office is an officer of the United States, and surely they also wouldn't think that it makes any sense to give an insurrectionist former president a free pass while you would disqualify some low-level clerk who did the same thing by engaging in insurrection.
Leavenworth, Indiana is next. This is William. Good morning.
Good morning. Thanking my call. This is an 8th attempt to get on. As far as Trump goes, his actions speak much louder than words, and with all the criminal indictments against him, that should tell you something. I've had it with the elected dictatorship that we've been suffering with the two-party system for years. Best is bad candidate. And when it comes to the Supreme Court, I don't see a lot of faith in that when corrupt justices like Roberts and Thomas refuse to recuse themselves in this case. And I have so much more, but very little time. Thank you for yours.
William, thanks
Have a good day.
Thanks for sticking on the lines for us. Mr. Blackman, you want to start here?
Sure. So I do have faith in the Supreme Court. Maybe I'm an outlier in Washington. I do think the court will take this case seriously. I also think that when you're talking about a provision of the Constitution like the 14th Amendment, you have to look at what came before it. And the Constitution was ratified in 1788. You can go walk to the National Archives and see it. And if you look at some of the provisions there, the phrase officer of the United States is used. For example, the Appointments Clause says the President shall appoint the officers of the United States. Appoint. The Commissions Clause says the President shall commission the officers of the United States. That's something the President gives to someone who is appointed. The Impeachment Clause separates out the President and Vice President from the officers of the United States. And the Oath Clause specifically says that the President has a separate oath. He doesn't take an oath as an officer of the United States. So look, I agree with Ilya that these are legalistic arguments, and perhaps the man in the street may not look at it, but if I had 5 minutes to explain them, I could probably explain to them pretty easily. A related point is that there's actually not records from the 14th Amendment's debates about officer of the United States. People discuss another phrase, office under the United States. So this is the question of whether you can disqualify someone from the presidency. There's a lot of debate about saying Jefferson Davis cannot become president. I'm not going to deny those. Those exist. But there was just no debate of this because they didn't think about someone who had held one office, and only one office, as president. And to be clear, if a person held no government position and then joined the Confederacy, they would not be disqualified. It's only for holding certain governmental positions.
Professor Soman, setting aside this disagreement that you obviously have on officer of the United States, to the caller's point about justices should or shouldn't have recused themselves on this case, do you have any thoughts on that?
So I see no reason why Chief Justice Roberts should recuse. There is an argument that Justice Thomas should recuse on the basis that his wife was a prominent supporter of Trump's and of his efforts to overturn the results of the 2020 election. That said, in the past, justices have sat on cases where their spouses had been involved in some sort of political activism related to it, and ultimately there's little in the way of hard and fast rules about when Supreme Court justices should recuse. Finally, on the officer of the United States issue, I think these hyper-technical points about the 1780s, which I think are actually questionable, and we can get into them in detail later, they don't determine the ordinary meaning of Section 3 in 1868, 80 years later, and they certainly wouldn't lead an ordinary reader to accept the absurd conclusion that an insurrectionist former president gets off scot-free while an insurrectionist lower-level official is disqualified. It's very obvious that an insurrectionist former president, especially if he engages in the insurrection while president, is much more of a menace than somebody who was a low-level official and did it.
Mr. Blackman, just coming back to recusal for a second.
Sure.
Do you think Clarence Thomas should have recused himself in this case?
No, I mean, the gravamen of the allegations that Ginny Thomas, who's Justice Thomas's wife, I think she was at the lip speech on January 6th. She did not go to the Capitol. I think she sent some form emails to members of state legislatures urging them to not certify the votes. I think she texted some people in the White House about the election. People have a right to redress the government for their grievances, or petition the government for redress of grievances. And I don't see how you have to impute every single political action Ginny Thomas takes to her husband. As Ilya mentioned, I agree, there have been lots of presidents and lots of judges who've had politically active spouses. I don't see the basis for recusal. I think people are just trying to make Justice Thomas look bad, and it's been a pretty sustained effort.
Josh Blackman, a professor at South Texas College of Law, Houston, will head to Houston. Carl, good morning.
One of my students, maybe.
Good morning. I'm not an attorney. I don't really know what to say, but I remember when states like Texas and all the southern states argued about states' rights. And now a state say, hey, listen, we don't want this guy who committed insurrection on our ballot, but yet they want to do away with states' rights. What about states' rights in this issue? Thank you.
Ilya Soman, you want to start on this one?
So I think there is an element of both federal and states' rights here. Obviously, what we're talking about is an interpretation of the federal Constitution, and the federal Constitution does limit the states in this area. They're not allowed to have certain kinds of office holders if those people had previously engaged in insurrection and had previously held offices. On the other hand, there is a states' rights dimension to this case in that what Section 3 says is that a person who previously held office and engaged in insurrection cannot hold the office, but it doesn't in and of itself address the issue of ballot access. Ballot access in the first instance, at least, is controlled by the states. But the reason this case is in court is that Colorado state courts have ruled that in Colorado, as in some other states, you can't be on the ballot unless you're constitutionally eligible for the office that you're running for. And that part is a matter of states' rights, because there are some states that don't have a rule like that. So what we have here is a kind of combination of federal constitutional power and state authority over ballot access.
Professor Blackman, states' rights.
Right. I think I agree with Ilya. It's a sort of a weird dichotomy where Colorado is asserting the power to sort of enforce the federal Constitution, and then Trump is saying that no, Colorado, you cannot do this by yourself. You must have a federal law, an act of Congress. So it almost turns the states' rights argument on its head. One of the arguments that I advanced in my brief is that we do, in fact, need federal enforcement legislation. We cited a decision by Chief Justice Salmon Chase from 1869 called Griffin's case, where Chase seemed to suggest that you need to have a federal law. Now, this was not a Supreme Court decision. It was a lower court decision that the Chief Justice sat on. We think it's a good decision, and it's one that was largely accepted. People didn't really argue against it. And that might be another way the court can resolve this, by saying that Congress must take the action here.
So play this out hypothetically if the justices decide to side with the voters of Colorado in this case.
Well, it depends on what ground they do it. If the court affirms across the board, which is what Ilya was sort of suggesting before, then Trump is off the ballot in Colorado, and in candor, he's probably off the ballot in 50 states. It's over. If the court takes any one of the arguments that I've raised or the Trump lawyer raises, then it gets complicated. So one argument that's been advanced that we haven't mentioned yet is, well, we're in a primary, right? This is not a general election ballot. Maybe the Colorado Republican Party can pick whoever they want for a primary. If he's disqualified for the general, who cares? What that does is we go all the way through November to the general election, and then this case comes back to the court. Or the court can hold that, no, it's not for Colorado to do, it has to be Congress. Well, then what happens on January 6th of 2025? In other words, when there's a joint session of Congress and they elect the president in January 2025, what if Vice President Kamala Harris gavels a session and Democrats in Congress object to Trump? They say his votes were not given in a regular fashion because he's disqualified. So if the court rules in favor of Trump, it depends which approach they choose. It can let this issue linger all the way to the election, till January 6th, or even Inauguration Day. So the only clean way of resolving this is by taking one of the merits arguments, either that there was no insurrection, he didn't engage in it, or my officer position, right? That will cleanly resolve it, I think. But something short of that, the issue will fester for months to come.
Professor Soman, can you play out some of these hypotheticals for us?
I think to a large extent, I mostly agree with what Josh said here. I think if the court does rule the way I would want it to rule, then Trump would be on the ballot, off the ballot, at least for the general election in most states, though perhaps not all, because not all states have this requirement. In order to be on the ballot, you have to be eligible for the office that you're running for. Nonetheless, as a practical matter, Trump would have virtually no chance of winning the election if the court were to affirm the Colorado Supreme Court. And it's true, if it goes the other way, it depends to some degree on how they do it. If they rule that the president is not an officer of the United States, or if they rule that Trump did not engage in insurrection or something like that, then that would decisively end the issue. There are other paths that they could take that could potentially allow the issue to linger, like they could say that this doesn't apply at all to the election process and only applies to taking office, and in principle that could then let the issue linger in less than until Trump actually wins in November. I suspect the court won't do that, but they could. There's a couple other ways they could let the issue linger. For instance, they could rule contrary to the argument in my brief, but they could say Trump did not get enough due process for his claim, and then that would just leave open the door to further litigation in other states where Trump might get more process, such as a higher burden of proof or different trial procedures or something like that. So that also would allow the issue to continue to linger. I suspect the court would like to resolve the issue definitively now, but obviously I could be wrong about that, and that prediction may be worth as much as you're not paying for it.
About halfway through our conversation this morning with law professors Elias Soman and Josh Blackman, taking your phone calls. No surprise, plenty of callers for you. This is Eric in Brick, New Jersey. Good morning.
Good morning. There's 2 points that I wanted to raise. One is, has anyone advanced an equal protection argument? So I'm a resident of New Jersey. This is a national election, and yet the Colorado system is minimizing or weakening my vote. So that's one thing I wanted to address, if you could respond to that. And the other thing is, how is it that Texas can be told, you're a state, you're not the national government, so you don't have a right to put up a barbed wire fence, and yet Colorado has the right to exclude a presidential candidate from a national ballot? Thank you very much.
Thanks for the questions. Josh Blackman, you want to start?
Right. So one of the arguments in favor of requiring federal enforcement legislation is uniformity. Right. If Congress were to establish a single process that we would know nationwide what it means to be an insurrectionist, what it means to be disqualified. But when we have what might be called a 50-state solution, each state can take it upon itself to decide who is and who is not in the ballot. I think it's especially problematic when you're electing the president, because, as Ilya said, you need to be on the ballot in just about every state to have a chance of winning. If you're only in the ballot in half the states, your odds of winning the Electoral College go down substantially. To your second point about what is a state, the Constitution does give the states the power over the manner of appointing presidential electors, of how the electors are chosen. So I think that does give the states some leeway. But to your other point, it becomes problematic when when you have a national election that's so fragmented, which is why I think, for better or worse, the Supreme Court needs to provide a clean resolution about this. I think it'd be very chaotic if each state took it upon itself to decide whether Trump is and is not in the ballot. If you thought people lost confidence in the last election, I think if we had a 50-state solution, people would lose even more confidence in this election. And I don't know how that plays out.
Professor Soman, equal protection and state actions here?
So the fact that each state controls ballot access for itself is just a fundamental feature of our election system, and it's the way things have worked through every election that we've ever had. And in every election, we've had some presidential candidates, usually minor party ones, but still, that are on the ballot in some states, but not on the ballot in other states. And If you don't like that, that's a flaw in the constitutional design. You would have to have a constitutional amendment to get rid of that. Yeah, some people would be angry if Trump is disqualified and they might lose confidence. On the other hand, lots of people would be angry if he's not disqualified because they would see the man instigated violence to keep himself in power after he lost an election, and then he got off scot-free despite the existence of a section of the Constitution that's supposed to prevent people who did that very thing from getting into power again. So I think there's no way that the court could rule here that would not anger a substantial number of people. So I think the court should try not to focus too much on, who will be angry or who will be happy about their decision, but just instead to try to do the right thing.
To the Yellowhammer State, this is John in Alabama. Good morning.
Good morning. Thank you for taking my call. The Supreme Court have to make a decision today, and whichever way it goes, you're going to have some people that are unhappy. But the Supreme Court also take an oath when they are sworn in. And one of the things that I look at is Clarence Thomas. His wife, while the insurrection was, I guess, going on, she made calls and text messages to people in Trump's administration. I think one of the people that she spoke to was Meadows. So I think Thomas should recuse himself, because by voting that Trump is an insurrectionist, he will also be voting that his wife took part in that insurrection. So he's going to vote the other way. Thank you for taking my call.
It's John in Alabama. You both already addressed the recusal argument, but one of the first things the caller said is the Supreme Court is going to make a decision today. They're not making that decision today.
Probably not.
When do you expect they will make this decision, though?
So the rule of thumb is usually the court will hear a case and issue a decision a few months later. If it's a big case, it's the last week in June. This is not a normal case. The Colorado Supreme Court ruled in December. About a week later, the case was appealed to the U.S. Supreme Court, and then a couple days after that, the court granted the case. And they set argument for about a month after that. So we are on a super duper rocket docket, right? This is going super fast. I think the big looming deadline is actually the Colorado primary in Super Tuesday. I think it's on March 5th, if you probably know this better than I do. I think we need a decision before March 5th. It won't be today. If they issue a decision today, that'd be remarkable. That'd be super expedient. But I think we'll get a decision by March 5th. Let me just put this out there. We may not get a clean decision. It may be fragmented. That is, you may not have a single 5-member majority for any one analysis. Maybe you got 3 votes here, 3 votes there, 3 votes there for different rationales. And when you cobble it together, there's a majority saying either Trump is or is not in the ballot. But if we're looking for clarity from the Supreme Court, we don't always get that, especially if they're on tight time frames with a very contentious case.
Professor Soman, on time frames for a decision, and also historical precedent here, going back to the 2000 election and Bush v. Gore, remind folks of how quickly that decision came.
Sure. So I generally agree with Josh that the court is likely, though not certain, to decide this quickly. That's why they took the case on an accelerated basis. So they may well decide by March 5th. I'm not certain about that, but there's a good chance. Bush versus Gore, which involved litigation over the recount in the 2000 presidential election in the state of Florida, which at that point was going to be the decisive tipping point state. You got a decision, I think, within just a week or two. I don't remember exactly how fast it was, but it happened very quickly after oral argument because the Supreme Court wanted to resolve the uncertainty about who won the election before the electoral college votes would be certified and before some other deadlines that were at stake there. So I think this case, while the legal issues it deals with are very different from those of Bush v. Gore, it does have in common the fact that it's in the middle of an election season, and the court probably took the case on an accelerated basis because they want to have a definitive resolution relatively quickly. Whether they actually achieve that definitive resolution does depend in part on what exactly a majority of justices are able to agree on.
Cummings, Georgia is next. This is John. Good morning.
Good morning. Mr. Soman, I believe you said that a conviction of insurrection is not necessary because the people who engaged in insurrection during the Civil War were not given a trial. Well, if you're a member of the Confederate Army, by definition, you created an insurrection. You were part of an insurrection. So if you don't have a conviction in a court of law of insurrection, you leave it up to people's judgment as to whether or not someone is guilty of insurrection. So if I'm in a position of authority and I can make the determination as to whether or not someone deserves to be on the ballot, I could say that Joe Biden participated in insurrection because he allowed 13 to 14 million people to come into the United States through the southern border, did nothing about it, didn't follow the law. So I can make that determination. He could be kicked off the ballot if a court of law and a conviction is not necessary to determine whether or not someone participated in an insurrection.
Professor Soman.
What I said was that a criminal conviction is not necessary. However, if a state official, depending on the state system, makes a determination that somebody is not eligible for the ballot because they engage in insurrection, or for that matter, for any other reason, that person can then go to court and challenge that. And the court can hear evidence where the person can put forward evidence saying, you know what, I did not actually engage in insurrection. In the case of Biden, he could say, actually, letting in some undocumented immigrants is not an insurrection, because it's not an attempt to seize the power of government by force. And B, I actually deported more people than Trump did, or in a higher percentage of border crossers than Trump did. So therefore, I didn't engage in insurrection. So it is simply not the case that one partisan official could on their own just simply decide that somebody engaged in insurrection is ineligible. Those are legal issues that could then be litigated in court, and ultimately potentially even go to the federal Supreme Court if the legal reason why the person is disqualified has to do with the federal Constitution as opposed to some state law. This is the way that issues of election qualification have been handled throughout our history, including when Trump himself brought cases against people in 2016, arguing that they were ineligible. His supporters, with his backing, brought a case, several cases against Ted Cruz, who was his main rival for the 2016 Republican nomination. They argued that he was ineligible because he was not a natural-born citizen. He had been born in Canada to U.S. citizens, and that issue was adjudicated in the courts, and ultimately Cruz prevailed. But no one doubted that state courts could address an issue like that, and similarly, they can address Section 3 qualification as well.
Mr. Blackman, can you take up this question from Steve in Massachusetts, texted it in this morning. Can you comment on whether the U.S. Solicitor General has filed an amicus brief on this case, and what is the position of the United States in the Colorado case?
All right, so the U.S. Solicitor General is the top lawyer for the government before the U.S. Supreme Court, and they will often file a brief on important cases, even if they're not a party, when there's a federal interest. There was a lot of intrigue about whether the Biden administration would file a brief in this case, arguing that either Trump should or should not be on the ballot. My suspicion was that General Prelogar would not file a brief because it would basically be taking a position on Biden's lead opponent. And indeed, the government has not weighed in on this case, so we don't know what the government's position is. They've been actually silent. The only lawyers are at the court today are Mr. Trump's lawyer, the lawyer for the Colorado voters, and the lawyer for the Colorado Secretary of State. I actually asked for argument time. I didn't get it, so I'm here and not there.
Why the Secretary of State? Why did they get 10 minutes?
I don't know, actually. There are some issues about election law, and she wanted to have her say. The Colorado voters actually opposed the Secretary of State. I think she can only help Trump, to be completely honest. If she throws some muck in the works of what the lower court did, that actually helps Trump. But, the court usually hears from a sovereign state if they want to argue, so they let her.
Professor Salmon, any thoughts on the role of the Colorado Secretary of State today in those 10 minutes?
So I believe that they got the 10 minutes because part of what the issues at stake in this case are Colorado's authority to determine ballot access and to adjudicate Section 3 issues, even in the absence of a congressional statute. There may also be some technical issues of Colorado law. In general, the issues of Colorado law, the Colorado Supreme Court is supposed to be the final authority on that. But Trump's lawyer has argued, I think very unpersuasively, that the Supreme Court could somehow review even some of the state law issues in this case. And maybe the Secretary of State perhaps is going to address that.
Just about 15 minutes left in this segment. This is Brian waiting in Washington. Good morning.
Good morning, Washington Journal. Hey, you guys are talking about Bush versus Gore. I've been thinking how much that Roberts court has given us, by those guys deciding to shut down the recount on the 2000 election. We've got 9/11, we got the 07 collapse of the economy. It just goes on. And then we've got Putin. I remember watching and accusing Bush Cheney of going into Iraq. It makes me think that it gave Putin the green flag. But to your
we'll hold off on conspiracy theories. Do you want to talk about the role, though, of the Supreme Court in this country right now, and trust of the Supreme Court, and what this case could do for that?
Sure. I mean, John Roberts was confirmed in 2006. That was several years after Bush v. Gore, so I think there's a little gap between the history there. But I think there's a fair point, right? Chief Justice Roberts, for better or worse, seems to care how the court's perceived. He often speaks of legitimacy. That's the key word they use, the legitimacy word. And I think there are two ways of looking at this, right? I think Ilya and I probably agree on this. No matter what the court decides, half the country will probably be unhappy, right? If the court decides that Trump stays on the ballot, then people say, wow, that's a bunch of Republican judges keeping a Republican on the ballot, okay? If the court kicks Trump off the ballot, a lot of conservatives say, well, these were never really conservative judges. These are judges who are basically beholden to liberal interests, and they're partisan. It would be nice if there was a unanimous ruling either way, 9-0. If it's 5-4 or 6-3, 9-0 is better. I don't know if they can cobble together 9-0, but I think a 9-0 ruling, no matter what they do, would be better for the court's perception.
Professor Stoneman, you have Dawn out of St. Petersburg, Florida. Good morning.
Good morning. Thank you for allowing me to speak. I have a, comment question for Mr. Salmon. I'm sorry if I didn't say the name right. If you could clarify better what you meant by protect democracy from voters and ignorant voters. As voters, that is our voice. Our voice is our vote. So to protect against what you're calling voters and ignorant voters, is that not a slippery slope to voter suppression? And then as what you said, as far as a lack of conviction being a weak argument, due process is a constitutional protection and the right to face our accuser. Denial of that process and jumping to public opinion conviction is unconstitutional.
Professor Stoneman.
I think there's two questions there. Let me take them in the reverse order. It is certainly true that the 14th Amendment and the 5th Amendment require due process of law, but they only require it in cases where someone's life, liberty, or property is threatened by the government. In this case, Trump's life, liberty, or property is not threatened in any way. All that he would lose, should he lose this case, is the ability to hold various government offices. That's not liberty, that's not property, and that's certainly not a threat to his life. Even if you assume that due process does apply, the civil court process that he got a 5-day trial in Colorado is more than sufficient process for this kind of situation. It is actually more process than the Supreme Court says is necessary in cases where the government deprives someone of welfare benefits that are necessary for that person to remain alive. So even to the extent that some due process is necessary, Trump very much got it. Finally, on the issue of voter ignorance, our system is not a pure democracy where a majority of voters are just allowed to do whatever they want. Voters do have a lot of power, and they should have a lot of power. We wouldn't want a small elite to just control everything. On the other hand, the framers of the Constitution, both the original Constitution and the 14th Amendment, were very afraid of voter ignorance and other problems, and they were also afraid that democracy, if not constrained in certain ways, could destroy itself, as they had seen it almost do in the Civil War when voters in the South had elected people who wanted to launch an insurrection for the purpose of protecting the horrible, evil institution of slavery. So the Constitution has a number of constraints on voter choice in order to protect democracy and to protect our system of government more generally. And one of those constraints is Section 3, which says that if a person had previously held various government offices and they engaged in insurrection, then they wouldn't get another chance to hold power in the future and do it again.
Josh Blackman on voter ignorance.
Well, this is my good friend Ilya's long-term scholarly project. He's written a lot about voter ignorance. People should know Ilya was actually my professor in law school, so it's kind of nice to be sitting with her many years later. What I would say, though, is that despite Ilya's, I think, long scholarly record on this, when people hear vote ignorance, they usually react the way that the caller just did. And I think the average person on the street who sees this decision will say, if Trump is so bad, we shouldn't elect him, not that 5 members of the Supreme Court should take him off. We talk a lot about how people perceive it. And just anecdotally, I've been listening to this program for about an hour. Most of the calls seem to be favoring, leave him on the ballot. He's an awful person. I don't know how people say, you know what, the court should be taking him off. And I think that might actually be the less popular position, but I'm not sure. We'll see what happens.
Niagara Falls, New York, this is John. Good morning.
Good morning. Hello?
Go ahead, John.
Yeah. I was just wondering, isn't a lot of your callers and everything seems to think that just January 6th was the only incident that's on what he's going to be answering for today? Wasn't his attempt to overthrow the government by false electors and stuff multifaceted? And I guess that's really what my question is. And is there more than one charge that he could face, you know, like espionage, for instance? Would that include part of a insurrection act?
Ilya Soman, the caller may be getting into some of the other charges that a former president is facing in some of these other cases that have been brought against him, specifically the federal cases.
Yeah. So Trump is facing criminal charges for a number of his efforts to overturn the election, both federal charges and charges in the state of Georgia. That is distinct from the Section 3 issue, which is not about criminal charges, but about whether he's disqualified from holding various public offices in the future, which in and of itself is not a criminal law issue. However, it is true that the Section 3 disqualification issue involves not just what Trump did on January 6th itself, but also his efforts to instigate violence and overturn the results of the election even before January 6th. And if you read the opinion of the Colorado Supreme Court and also the opinion of the trial court in this case, those decisions actually go into that evidence in great detail. What he did before January 6th, some of it at least, is relevant to this issue. But I do want to emphasize that the criminal charges are a distinct issue from the civil issue of whether he's disqualified under Section 3. Merely being convicted of criminal charges does not by itself disqualify him. On the other hand, not being convicted of criminal charges does not mean that he's allowed to stay on the ballot or to hold office. These are distinct issues.
Professor Soman, how far do you think presidential immunity goes?
So presidential immunity is also a distinct issue from this case. In the criminal cases against him, Trump has argued that because when he was president, he was immune from almost any criminal charges on anything that he did in office that in any way related to his duties. The D.C. Circuit, the Court of Appeals that heard that issue, has just rejected that argument, I think rightly so. But even if Trump is immune from criminal charges, which I believe he is not, but even if he is, that doesn't mean he can't be disqualified under Section 3 of the 14th Amendment because Section 3 is not a criminal issue.
Josh Blackman on presidential immunity.
Right, I think I agree with Ilya. The question of immunity from criminal charges is separate from the question of whether Trump can be disqualified. But I do think it's worth noting that no one has been charged with insurrection. Not the Proud Boys, not the Oath Keepers, no one. I think that goes to say something that perhaps the federal government doesn't think there was an insurrection, or maybe they're not sure, right? We haven't talked about this much. We don't know exactly what an insurrection is. There's a federal insurrection statute, doesn't define it. And there's a lot of authority about what insurrection is and is not. I think in many regards, whether it's insurrection is a question for the court of history. Right? It's something that political scientists can study many years later. But in the moment, it's sort of hard to sort of separate ourselves from what happened on January 6th, what happened before and after that date. At what point was there an insurrection? When Trump gave the speech, when people break into the Capitol, when he gave a tweet, when he didn't give a tweet. These are some fairly fact-bound questions, which the trial court made extensive findings on. And I don't know if the court wants to go down that road to decide what is and is not insurrection. That's why one of these other paths might be more likely grounds for resolution.
Do you think the Supreme Court will go down the road of trying to decide how far presidential immunity extends?
Well, the Supreme Court might just deny review now, which would be whole kit and caboodle. If the Supreme Court says, you know what, we're going to take this case up in the regular course when Trump loses. I mean, usually when a criminal defendant goes to trial, you appeal after the trial. Trump is trying to basically appeal before the trial begins. So the court could just say, you know what, we're just going to hold our hands and wait for the trial to happen. We'll maybe address this later. If the court does that, then we go to a criminal trial. We might have a conviction. If the court takes the case, I suspect, Illy probably agrees, they probably will affirm. I don't think they'll reverse it, but they might narrow the decision below in some regards to maybe give some more protection to future presidents, but at least Trump might have to stand for the trial soon.
Is that about where you stand, Professor Soman?
It's where I stand on the issue of immunity. On the other hand, on the issue of insurrection, I think it's fairly clear that an attempt to seize government power by force and keep in power the person who lost an election instead of the person who won it, that is an insurrection, even under a narrow definition of the word. And there's actually historical evidence that in the 1860s, when the amendment was enacted, they had a fairly broad definition of an insurrection, which included any kind of violent resistance to enforce under a federal law if the person who did it for a so-called public purpose. That is, they thought the law was unjust or wrong in some way. I have some qualms about a definition that broad, but you don't have to have that broad a definition to include what happened on January 6th and any sort of ordinary meaning of insurrection, both today and in the 1860s. It surely includes an attempt to use force to seize the power of the government, and that's exactly what happened on January 6th.
Less than 5 minutes in this segment. Let me try to get a few more calls. Mark, Cloverdale, Indiana. Good morning.
Good morning. This is an ignorant voter that has an IQ of 130, so I'm talking to Mr. Salmon. You can't come up with a definition of what insurrection is. Is insurrection asking people to go peaceably to the Capitol? Is that an insurrection? Asking the state legislatures to examine their legislative electorates, is that insurrection?
So I just did mention a definition of insurrection, which is that an insurrection is an attempt to seize government power by force. That's exactly what the people who stormed the Capitol on January 6th did. And Trump engaged in the insurrection by instigating not just on January 6th, but over a period of many weeks. He then, while the attack was actually going on, he tried to leverage the insurrection to try to stay in power. Like during the very time the attack was going on, he was calling members of Congress while they were under siege in the Capitol, trying to continue to push them to reject the electoral vote and keep them in power. So by any reasonable definition of what engaging in insurrection is, using the violence as leverage to try to get your way surely is a form of engaging in insurrection, and instigating it not just on January 6th, but over a period of many weeks also is engaging in insurrection. If you want to know more, there's a very detailed and excellent discussion of this in the Colorado Supreme Court's opinion, and also in the ruling of the trial court in this case.
Josh Blackman, you have Liz in Marlton, New Jersey. Good morning.
Good morning. Enjoying this discussion, but I frankly think some of the professors of history who have discussed what it meant in the 1860s and what the 14th Amendment means once it was written and adopted. I think if we just take the historical view, I think, unfortunately, one of the downsides of a lot of lawyering about the U.S. Constitution is that we can always find lawyers who will tell us something that's quite clearly black is instead white. They will come up with very creative ways to undermine the actual words of the U.S. Constitution. And I think we need to have, for the American people, upholding the U.S. Constitution as it is written. And that used to be something that Republicans, especially the conservative ones, adopted, but they've now jumped to the other side to try to justify an unfit insurrectionist president who should not be on the ballot if we are really going to live up to our constitutional writings. Thank you.
That's Liz. Just about 2 minutes left here. Let me give you the first of those 2 minutes.
Sure. I agree we should uphold the Constitution. The question is what the Constitution means. I wish this was an issue that was black and white, but it isn't. The Constitution lists a number of positions that trigger Section 3. The president's not listed, so we have to decide whether this phrase office of the United States means appointed or elected. There's lots of cases I can cite to support my position, lots of authorities, lots of contemporary history we can cite. But ultimately, we have to have a decision by the Supreme Court to decide what this provision means. I agree, ultimately, let the people decide. That's a useful framework, and I think that's probably where the court will come down, but we'll see.
Professor Soman, final minute.
Yeah, so I would say that, yeah, lawyers sometimes make convoluted, problematic arguments, and that's true of some of the arguments in this case. Hopefully, the court will focus on the plain text as it would be understood by ordinary people, which is what the court has told us in the past is the way to interpret it. And if you reach that result, then in this case, you would have to conclude that the person who holds the most powerful office in the federal government is an officer of the United States, and also that Trump did engage in insurrection and therefore is disqualified. I'm not certain by any means that the court will decide it that way. Sometimes convoluted arguments do prevail over the plain meaning of the text, and the court's jurisprudence is not completely consistent on those kinds of issues. However, they do have considerable experience, at least, in looking at arguments that lawyers present and trying to separate out weak ones from strong ones.
We'll have to end it there. Elias Soman, professor of law at George Mason University's Antonin Scalia Law School. Josh Blackman, professor of law at South Texas College of Law, Houston. Appreciate your time this morning.
Thank you so much.
Thank you.